we're going to sit right up here. You want to
Okay, sure.
So, hello? Yeah, fish guy back.
Oh, Janine, we need to start.
Brett.
Do you have it? They're on. Okay. We're gonna start on 12 and finish that up.
All right. We're going to resume on item 12. All right, we're ready to start. I always hate to interrupt something where people are laughing. That's a good thing in life. So you always want that to continue if possible during trying times for whatever reason. Okay, so let me see if I have this right. Feel free to correct me in where we are on 12. Where we left off, unless you did a little bit more, was staff had come up with another change sheet to respond to much of what they heard from us and from the audience yesterday, which is great, and we'll go back to that. And then we hadn't asked other questions, either of our staff or of others. So thank you for coming back. Really appreciate it. So I have some questions, but I'm happy to turn to my colleagues with other questions related to item 12 after yesterday. No more? Do you have any? All right, let me ask it. We can go back and forth. Let me just ask a few. I mean, one of my set of issues had to do with the level of deference to agreements. I think you've tried to... Oh, sorry. It's on. It's just not close. Gosh, everybody got me that time. You didn't even need to step in. Thank you for the group assist. So the issue of deference to agreements and figuring out how to make the process a little more nimble so it didn't feel like multiple bites of an apple that might never happen, you've dealt with, and we'll talk about that a little bit more. I actually do want a little more explanation for the recommendations on the flow levels suggested in the backstop. I suspect at its simplest, it's looking at the riffles and how much water it would take to get over the riffles. The issue that was raised by at least one of the speakers, if not more, was what about a non-flow way in an emergency situation to deal with it that wouldn't cost as much water to the other users? Because as we're trying to figure out what's reasonable, it's sort of reasonable on every side. And so I actually did want to ask you all, because there was a reference to some hesitant from at least one of the agencies to a non-flow alternative of doing a little deeper channel. And I know there are concerns, but I want to hear more about that, because if there's a non-flow way, because you guys are doing all kinds of amazing things, trucking fish and doing stuff, I want to understand why on these streams the numbers you came up with seemed so essential as opposed to other options. That was a fair question that was raised, and we didn't ask you to respond to it at the time.
Yeah, so I can take a shot at that since I'm not with my DFW counterparts today, so bear with me. But
so you get to say whatever you want.
Yeah,
this is your moment, fish guy.
I don't think channel modifications are something we're opposed to. We're involved with channel restoration and channel modifications with the fish agencies quite frequently. Our perspective is when you do get in the water and you do some manipulations in water, you can increase turbidity. And if there are fish present in the vicinity when the work is going, there could be some additional stress and adverse effects that come from increased turbidity levels, and those could be compounded by higher water temperatures. So the careful application of channel modifications is probably the best way to go about it. So jumping out and doing it for the spring flows is something that gives us a little pause and a little bit of caution, concern about, because of those effects related to turbidity, and also the fact that channel modifications could, you know, the fish could be right there where the heavy machinery is going. So we would prefer to take a more deliberative approach where we went out into the field this summer and looked at the opportunities for channel modifications and got a better handle on it. So conceptually, I think we're okay with it if it was something that could be done during the summer, very low flows when fish are not present, and then benefit them for the fall period. So, but it's hard right now to know if we would need to modify 1 riffle, 2 riffles, 3 riffles, so forth. And then the other consideration is the indirect effects that such modifications could have on fall run Chinook spawning habitat, because fall run Chinook spawn on these riffles that we're talking about.
really?
So we want to be careful not
Really?
to have an adverse consequence for another race of Chinook salmon that could co-occur in that vicinity.
Okay, that's helpful. Helpful. Council. There, again, the use of terminology is always challenging, and the implication that somehow, let me just say one thing. I mean, business as usual is something people are more comfortable with, and I completely understand that on all sides. We're not in a business as usual experience in that we're dealing with the worst drought in terms of impact, you know, that we've seen in modern history, in part because we are integrating, and we have to integrate the environmental considerations that we had not been integrating in past serious droughts, and that does make it more challenging, makes our job more challenging in figuring out what the right thing to do is under the law. In using the waste and unreasonable use emergency reg vehicle that we have, there were at least one, but maybe more people yesterday that were concerned, stated a concern, took umbrage, just I think a genuine concern that what we were saying is that other uses of water, other than the fish use, were somehow by definition less reasonable. And what I heard you saying, kinda, was that taken as a whole on a water body, taking all the water out to the extent that it would really seriously harm, particularly an endangered fish, let alone an important fish, but an endangered fish, was collectively unreasonable, and that this reg was designed to try and help adjust that problem, that we weren't calling the water use for cattle or orchards or whatever people were using it for unreasonable per se, but that the collective draining of these streams was what we saw as unreasonable. So can one of you, any of you, talk a little bit about that argument? And I would actually want it written in a way that makes that really quite clear, because I am concerned that people will be perceiving, whether it's what we intend, that we're making a more broad-based declaration on what's reasonable, as opposed to using the waste and unreasonable use term. And also, I know it's the subject of litigation, and some lawyers think that we'll lose the case that's on appeal. You all, I'm sure, think we're going to win. I don't want it. This is part of why I didn't ask it yesterday, but if you can help illuminate it for everyone but the litigants in the room, in terms of why using this particular tool is appropriate in this circumstance.
Yeah.
I'm looking at you because you look like you're the one who's going to answer the question. It looked like Mariana was going to answer it before, so.
Is she more excited about it than I am?
David looks so eager, I decided to sit back.
You were looking at me, and no, I'm happy to answer the question.
Illuminate for the
Yeah.
listeners and what you mean, and I actually would like the written product if this is indeed what we do, and that's an if because we're not done with the discussion. I think it needs to be made more clear, because I wouldn't want folks to either infer or imply that we thought that ag use was somehow unreasonable, because it's not.
Absolutely. I think that the way that we approached this was that the regulation itself was not necessarily the best place to provide that type of a full-on analysis, because it's regulatory language. So we're sort of limited by the constraints of OAL and trying to make things readable and internally consistent. Right. We did try to craft the resolution as best as possible to highlight the fact that this is an emergency situation. This is absolutely and unequivocally an emergency situation. And what was done here was to craft an emergency regulation that was as narrowly tailored as possible to address one absolute imminent need. And that's not water for fish. in general. It's water for fish in 3 tributaries that support natural runs of endangered, federally listed and state listed species for migration into upstream habitat, that there are no upstream diversions that could release water to otherwise provide it. So it is a very, very discrete situation that we're addressing here. And we looked at, certainly staff poured over all of the beneficial uses, all of the water rights on all of the creeks. We know what the uses are. I did hear that happening, that discussion a lot yesterday, that we should look at what the uses are before we determine them unreasonable. Well, we did look at them, but I think you hit the nail on the head that what we're talking about here is we've identified one particular discrete use, and that the other uses, with the exception of the minimum health and safety that we've carved out, because that is, again, also discreetly categorized as something that requires, in the current situation, this degree of protection, we've determined that those are unreasonable as compared to this one discrete use. They're reasonable in all their situations. They're beneficial uses. The board has, by regulation, defined what all the beneficial uses are. The process for determining reasonable use is always in flux. Is what is a reasonable use changes as circumstances change. We're doing this, proposing to do this as an emergency regulation, in part because it expires in a short time period. We're not proposing to do this, and we have recently addressed a similar issue through the Russian River Frost Protection Regulations as a permanent regulation, which, if it ever goes into effect, will not expire at the end of 270 days. But the situation that we're in is a governor-declared drought emergency. I heard that clarified not long ago. 1058.5 specifies that in a drought emergency, you can use the emergency regulation process. In fact, I think the governor was intending that that's the appropriate process, both because it's quick to be implemented to address an emergency, and also because it does expire. So there was no intent to, and I don't think this does in any way, either set a precedent or permanently modify the reasonableness of any existing uses. It's the emergency reg sunset date, the 270 days that's built in, was part of why we took this approach, that the unreasonableness would hopefully be less easily construed, or less often construed as trickling over into a broad statement that these uses are unreasonable at any other time. And there are a lot of off-ramps built into this that we talked about, the local cooperative solutions that we also crafted in hopes of making those water uses, or allowing those water uses to continue while still meeting the one particular issue that makes those uses otherwise unreasonable. And I think that you adequately described that, or aptly described that, when you're talking about how the unreasonableness issue is arrived at. So, I mean, I think that staff, I shouldn't speak for everybody, I think that we feel that the resolution may be more by positive framing as opposed to by saying these uses are reasonable in all their situations. I think we sort of took that for granted, because this is not changing any of the water rights rules regarding that, or setting any new precedent or doing anything different. So I think we sort of left that as is. That's the rule. That is absolutely the rule. Those uses are reasonable unless declared unreasonable, which means in every other situation pretty much. And they're absolutely beneficial, and we support them and have done everything we can to let those continue. But based on almost every one of the now 17 or so whereas clauses in the resolution, we tried to highlight how narrow and how discrete the emergency is, and why this process was chosen to just address that emergency, to address it narrowly, and so that the other uses could continue as best as possible. I hope that gets at what you're asking. I know you're
No,
suggesting
it
that we
does. I
sell
think that
this.
two things. One is I understand the reasoning for having the language of the reg be as crisp as possible, and there are a lot of whereases. We may want more by the time we're through, just to not be misunderstood. Because as I think I said either earlier today or yesterday, they're blending together. In the absence of clarity, folks assume the negative and fear the negative, legitimately so. And so it's as important, it seems to me, to be able to allay concern on all sides. It's just important on all sides. The framing would be that it's not reasonable to completely ignore the fish. You're also not asking for everything the fish might want. You're asking for a very small window. And part of my question was to be how reasonable, again, the application of this might be, and that goes to both the judgment of the fish agencies, but also the judgment of the deputy director as to when to implement. And it's not quite as faith-based or trust me as I said yesterday, but there's still an element of that. So the extent that we can articulate it as clearly as possible, either in the regulatory language or in the accompanying framing document, I think it's just better public policy to be absolutely clear, because we are in such an extraordinary circumstance that people are nervous. They're nervous. We had a lot of people coming up and saying they were just talking about precedential value. Completely understandable, exactly what a good water rights holder, water rights attorney should be doing. And so it just behooves us, if we feel we need to take extraordinary action, that we put in as much limiting and comfort language, both, as we can to say what narrow circumstance we mean. So I know I'm focusing a lot on the wording and the narrative, but I do think that's important.
I don't know if this helps, and certainly there probably wasn't enough time for it to be helpful enough to the general public because of how much time we had to prepare and how much time they had to prepare. The resolution is approximately 4 pages. Mm-hmm. The regulation is longer, but like I said, not the elegant place to put the public policy issues. Our sort of digest document, regulatory packet document that we sent out to the public with the LIRIS list and the notice of this was much closer to 60 pages and very in-depth discussed all of these issues. And you know, we tried to keep the resolution narrower, so we'll take whatever we can within the time that we have, as you would like us to, from that document or from wherever else, to make this as clear as you all would like it to be as to the public policy that you're espousing. Mm-hmm. We were very mindful of that, and it's in different documents that did go out, but I understand that people may not have pored over the documents and may not know them as well as we who spent all of our time writing them do. So I'm not, we'll do the best we can. I'm not sure on our timing here and what exactly, how exactly you'd like us to address that. It seems like the sort of thing that if you want us to, or some of us to get off to the side and do something in a specific way, we could absolutely do. But if we're up against a time crunch, I do my best to tell you it's there, and we tried everything we could to explain the absolute necessity and make it as much of, to reflect as much as we could the public policy aspect that we expected and heard from the board as being very, very important.
Good. Okay, go ahead.
In the resolution, number 9, which is where we talk about waste and unreasonable use, can there be an affirmative statement about the narrow focus of this particular paragraph, of this particular whereas? That it's narrowly focused on the endangered fish, you know, you said it well, the endangered federally and state listed fish,
Yeah.
rather than, I mean, this does, if you read this one paragraph, it's, it does, you wouldn't necessarily leap to the conclusion that it's not more broadly applicable. So that would be one suggestion.
Yeah, I think that we could easily add some language to paragraph 9 that discusses 2 points. I think one is the one that I mentioned just a minute ago about, and it's not mentioned in here because this is more explaining how we got to where we are, but that's that what is reasonable is a determination that varies as situations change. We can do a legal site if you want, but that point comes directly from case law, and we can mention that as well as some sort of tie together about the discreteness of this. I think we can put it in 9 or add in another paragraph.
Yeah,
I
well,
just appreciate
I'll remind everyone, though, that 10 and 11 do have more specific detail on those points. 10 is staff's attempt to explain why such diversions would be unreasonable in light of supporting minimum flows for endangered species. And then number 11 touches on the issue of the human right to water and the minimum health and safety flows. So there is some language there. Whether it's the best we can do, I'm not clear, but
I appreciate that. Maybe if we're looking to more elegantly say it, I think that we can at least add in those 2 points, whether in 9, and I appreciate you pointing to a good spot for that, or between 9 and 10 or something else.
So you would want us to clarify that, put in some language that references not just the drought, but the extraordinary nature of this drought, and emphasizes the fact that this is a temporary fix, or not a fix, a temporary measure, and that's gone into the balancing and the determining of reasonableness. Is that?
Well, definitely temporary, but, and other board members should weigh in, but definitely temporary, but also there is a beneficial use that we feel is not getting taken care of in this emergency. And so it's that beneficial use that the fish represent that is that we're addressing in this temporary way. It's extraordinary.
Right. And would that encompass that it's not, that's where the reasonableness comes in, that it's not the other uses per se, but in a drought context, it's not reasonable to, we won't use extirpate, but to demolish entirely the ability of a beneficial use to benefit even a little bit, and then articulate everywhere we can how targeted what you're proposing is. Because in what I heard yesterday, it was more people talking about what things could mean, the precedential impact, or even not allowing something that is good to happen. I just think the more constrained, the more appropriate to the emergency. And as we do as we've been instructed in terms of doing emergency regulations on waste and unreasonable use later in the summer, even if we're talking about when you can water your lawn, we are going to similarly have to constrain it to in a drought, just as we have in 77, where we did the Mission Viejo and said, we didn't do it across the board, but we said an ornamental lake was not reasonable. It's reasonable the rest of the time, maybe, but it's not reasonable in a drought to do ornamental lakes without recycled water. That I'm just trying to pick one that I know off the top. So the language just needs to be constrained to the circumstance if we're going to do this.
Perhaps adding language clarifying that this is not precedential, even though it is by its nature not precedential, just to emphasize that.
Well, it's a piece of that, but it's also telling the story everywhere you can. I realize we don't have a lot of time, and I do recognize that in a regulation you wanted to stick to regulatory language, but I also think there is a very important public policy component in government to people understanding what we mean and what we're doing, because whether I've been in federal, state, or local, and I obviously have more years at federal and local, I think there's a lot of human energy cost to people feeling that government is unfair or insensitive. And so you have to take the time to show you are. I mean, the presumption is we're not. And I think I actually think people understanding what a government institution means is good public policy, and I've spent time, words, and money to do that. Quite apart from whether the substance is right or wrong, I also think the clarity of language is a constraint on discretion in terms of the intent of what we might do that's also helpful to people. There's the basic comprehension that I think is just part of good government that we frequently in our speed, we collectively, not you all, can forget because we think or we know it needs to be done, whereas our job inherently is one of service to the publics we serve, and part of that is explaining ourselves. Even just for, you can see how much we've been, you know, we can read something and think we understand it, even have a briefing, and then through the course of the conversation and the public comment, we realize we either didn't or that it needs something else. So again, the more, this is one where less isn't more. I actually have a question about something that Dee Dee raised, or Board Member Diadamo. I'm sorry, I'm so informal. Which was, and again, I'm asking these questions. I'm not sure what I think on the end. It's all these pieces will come together for me. Given that I think people, and maybe this is unfair, maybe I do, I love the fact that so many people are trying to do voluntary agreements, because I think that in a real place, in a real time with real people, you can frequently work out issues better than you ever can through any kind of even backstop. And I'm a firm believer in that, coming out of local, inherently local politics and government. So I like the idea of encouraging agreements, and some of what you've proposed makes clearer deference to agreements that are reached, which gives people some comfort. But Board Member Diadamo asked if there were any way, given the timing being tight, folks talked about the fact that part of why they weren't coming to agreement is they had to come here yesterday and today, and then before that to prepare for coming here. And her suggestion was, was there any way we could act on the regulation, either not send it to OAL or send it to OAL but have the ability to bring it back or not implement it, et cetera. And I just wondered what you had thought about overnight about whether there were any options along the lines that she had suggested, and I maybe have been overtaken by events and conversations with her. I was just curious.
We absolutely thought about that, of course. There are some inherent difficulties with the OAL process, but we have explored some different options, I think, to address that concern. And if you'd like, I'm not sure, we have some different options that we had discussed, but I think that it is possible to strengthen the support of the voluntary agreements. I think that also the backstop of the regulation strengthens and supports the voluntary agreements. And I'm not going to say in this situation, but certainly in our experience from the frost protection regulation, which may be entirely different here and may be similar, but in that situation, we saw a lot of diverters enter into agreements because of the, I don't want to say threat, but because of the presence of the regulatory process. So I think that there's certainly an advantage to that. In this case, I think that the voluntary process, at least with the fish agencies, came out so close to this that, like you said, and like some of the commenters said, they had to shift gears and not get to work on that. So I think that there is certainly the opportunity for us to provide some small, not excessive amounts of time before submitting to OAL, because I think we run into some risks if we sit too long on this after the board, if the board adopts it, before it's submitted to OAL.
Because it wouldn't matter.
That's
Right.
the main one.
That was the time emergency you all were talking. Do you want to restate it for folks who are listening who might not remember yesterday?
that the need for the emergency regulation, the emergency is
Right now.
present now, and if not addressed, potentially need not be addressed immediately. And that's not solving the problem. That's the whole point of acting nimbly and using the emergency regulatory process and the changes to the water code and the governor's proclamation suggesting the emergency regulatory process. So we're taking those seriously to suggest that we address the issue as quickly as possible, and the issue is now. So I think that we have talked about some language and some possibilities to add to the resolution that could direct the executive director to hold for a reasonable period of time, perhaps a week, to allow the 5 days a week. So I can't say exactly. I think once you get too long, it becomes a problem. But some short period of time for the voluntary agreements, I think most specifically on Deer Creek, to be finalized. Whether you think that approach is appropriate or whether you think that that goes far enough, and what happens if those agreements are reached, whether that changes something in your minds, or whether now that you have incentivized and given some time before it's submitted to the Office of Administrative Law, what you think would happen after that is kind of up to you, and we have some different approaches as well. Is that clear?
I actually have a counter proposal to that. And that is, rather than holding the regulations before submitting it to OAL, because I believed in the strength of the regulations as a motivating force to get these agreements not only finalized, but also implemented and being effective. My preference would be to strengthen and provide more motivation in the regulations for these cooperative agreements to be reached. And with that in mind, I would suggest that looking at the change sheet that was circulated just before lunch, the change sheets, I guess it's change sheet 31. Is it really change sheet 31?
No.
Oh, okay. Anyway, the change sheet that was circulated just earlier today, and looking at the new language for the, I think it's well, on this change sheet, for whatever reason, it's page 7.
Oh, because it starts at 5.
Because it starts at 5,
are.
okay. And this is the language with respect to the cooperative agreements and the deputy director's approval. I would suggest 2 change, and I want to hear from staff on this. The first one is, if the agreements has been reached with the service or the Department of Fish and Wildlife, instead of saying that the diverters may request approval and the director shall approve, why not just change it to the agreement will be accepted in place of state board issued curtailment orders under this article, maybe providing that other users of water will not be injured. I mean, make it a more strong, a more affirmative statement that these agreements will in fact serve in lieu of the curtailment orders. And then with respect to the subsequent additional paragraph in terms of the deputy director's approval may be subject to any conditions, I would propose eliminating that paragraph unless staff feels that there is, I mean, under what condition would you expect to have additional requirements beyond what's already been agreed to with the service and the department? What additional requirements do you envision needing?
So I can address both of those together. I can't specify exactly what the condition would look like, but what we have proposed as a change from yesterday, and you can compare by looking at the same document, because what was on there yesterday was essentially what's below for other cooperative solutions. There was an A, B, and C. The continued diversion is reasonable, other users of water will not be injured, and the relevant minimum flows will be met, or there's an agreement with the agencies. So the basis for the change, and not going as far, at least for our proposal, as automatically adopting the agreements is essentially avoiding injury to other water users, because
Yeah,
that's
that's
not
important.
something that the agencies, the fish agencies, are
Right.
looking at.
Right.
And I don't think we can say that in every situation the facts will automatically work out such, based on who's upstream, who's downstream, who's junior, who's senior, that there won't be injury to other water users based on these agreements, because the agreements don't inherently have to have well, I think you heard proposals yesterday that the agreements could potentially involve digging a ditch in the middle of the stream. If Department of Fish and Wildlife says, go ahead, we think that's appropriate, but that causes a turbidity concern for somebody downstream such that they couldn't use the water. They're not a signatory to that agreement. That's the type of situation that they may not be looking at that we would, both water rights and water quality.
But
So-
but since your proposed change would have those analysis and determination being made within 1 week of the request anyway, wouldn't it be more efficient for staff to participate in these discussions as they're going on between the diverters and the fishery agencies, and provide input along the way to ensure that other users of water will not be injured once the agreement has been reached? Rather than wait until they reach an agreement and then come back and say, oops, we can't approve it because so-and-so will be injured.
Potentially, but I think that there's a couple of problems with that, and I'm not sure that the diverters would agree. We heard yesterday the sort of confidential aspect of the discussions, for example, between DCID and the fisheries agencies. We have no idea what they're discussing, and I'm not sure. Maybe they do, but I'm not sure everybody else wants staff involved. I think in a lot of cases, for these individual agreements as to what they can do and can't do, will and won't do, I think there's a sensitivity that we are trying to not get involved. If anybody wants staff to participate, I'm sure that we would do everything we can to participate so that the maximum amount of a week before automatic approval of these agreements kicks in.
That's a good point.
And that was one way of addressing the issue of what happens and how quickly. I think that we would do everything we can in the situations where we're invited to make sure that we could turn that, the deputy director could turn that decision around much more quickly because of staff involvement if we're invited. So I think that that's one of the problems I see with taking the deputy director out of it. The other one is, we've talked a lot about this, but there really is the waste and unreasonable use finding underpinning to this, and I'm a little bit hesitant to delegate that
Completely.
to another agency and say that if they determine that it meets their needs, even though that is a major aspect of the regulation, that it is all of a sudden not unreasonable, because we do have the other injury issues and we do have the water rights priority issues. So we're really sensitive to the priority issue that everybody's been talking about. And I think that our goal with this was to keep a degree of deputy director approval, restructure it from yesterday so that it could move as quickly as possible and not really second guess the fish issue, because we're looking to the fish agencies for the fish issue, but to look at the issue as quickly as possible of what's under sort of our expertise, and that's the water rights and water quality, so that could be done very, very quickly. And so if you would like us to make that change, I think we can, but with the changes we made from yesterday to today,
Kind of.
we left that in so that there wouldn't be a rubber stamp. There would be a very quick, thoughtful decision made by the deputy director without second-guessing the issues under the purview of the fish agencies. So that's
No,
what we
thank
tried
you.
to-
That was very helpful. I think I will, with that, withdraw my request.
Did you want to ask your own question, opposed to me asking your question?
Are you,
I might have more, but go ahead.
okay, so my questions are going to be in two categories. One would be for mill and antelope, and the other for deer. So I guess I'll start off with mill and antelope. There is no emergency. I don't see that we have the authority. The central question, the very first question we have to ask, and it's right here, you know, in the PowerPoint, a definition. There's so many documents here today. Let's see if I can find it. On slide 3 of yesterday's presentation by staff, evidence of emergency. Emergency, a situation that calls for immediate action to avoid serious harm to the public peace, health, safety, or general welfare. And that's under the government code. And we heard yesterday that on Antelope, that the agreements capture 100% of the diversions. And with respect to Mill, the agreements capture 83% of the diversions, and the remaining amounts constitute 4 other users. And that, I may not be correct on this, but that Los Molinos is working with those other users in order to develop agreements. So there is a possibility that even on Mill, we'll get close to 100%. And, you know, I thought about this a lot last night, and really struggle with this approach that we're taking. But I think that I'd be more open on deer with some of the protections that you've walked through. But on Mill and Antelope, I just think that it is an overreach. And I looked at the drought or the voluntary agreements that put together by NOAA. I've got the agreements, and I'm happy to share them with you on Antelope and Mill. And it says here a recitation of the goals. First of all, to address the urgency created by the drought, NIMS and CDFW have developed the Voluntary Drought Initiative to reduce the effects of the drought on priority salmon and steelhead populations. So the whole point is to reduce the effects. And if the effects are being reduced, I suppose the fishery agencies entered into these agreements with that in mind, that these agreements will have the effect of reducing the impact. So we don't have an emergency. And I know yesterday there was a question about, well, how do we know that these agreements are going to stick? Because, you know, someone could back out. It's a voluntary agreement, and that is true. But the agreements also contain information on ESA enforcement, and that the whole point behind this is, you know, there are other tools. The Water Board is not, this process is not the only tool. There are tools under the Fish and Game Code. There are tools under the Endangered Species Act. There are tools under specific cases that we could bring on waste and unreasonable use. So just this one tool of the Endangered Species Act, I mean, out of my 20-year history working on ESA issues, I don't take ESA lightly, and I know that the growers don't take it lightly either. So they're looking for some coverage under the ESA, and they're going to get it with this document, you know, presumably, you know, through enforcement discretion. I think Mr. Manassian quoted some sections, you know, yesterday, but that anyway, so I don't want to go into more detail on that, except to just say that they're, you know, the growers they didn't enter into this lightly. They're doing this because they want to have protection under ESA. And then the last point that I'll make is that this is, and this is just sort of the human element. To have growers that are in the middle of some dire situation here with the drought, for them to enter into these voluntary agreements, and no disrespect at all intended to NOAA and Fish and Wildlife, because I really appreciate you sitting through 2 days of this and all the effort that you've, you know, engaged with the growers, you know, and the water districts on the ground. But typically, growers don't view you as their friend. And for them to agree to enter into these voluntary agreements to provide for diversions that they don't feel, this is a property right, they don't feel they should have to do this. And then for us to come in and say, well, you know, we don't really trust this, we don't really know, maybe something's going to happen, and to sort of second guess that process. we have to really think about it before we take that extra layer, we include an extra layer of protection. Because I think that what we really should do instead is trust that they've entered into these agreements with good faith. And we want to encourage more growers to enter into these agreements, not just on these priority tributaries, but throughout the state. And for us to come in and second guess what those agreements mean, I mean, I think we should jump in where we see that there's a problem. And so that's why yesterday I initially said, why don't we consider adopting something and then holding it back and then see if we need to by way of a backstop. But the more I think about it, I think we should just embrace what they've done. And if there are any indications of a problem, you know, what can we do to help assist rather than saying that we're going to be, you know, stepping in here second guessing. So I would, and I plan on, in the event that there's a motion for adoption, I plan on introducing an amendment to strike mill and antelope. And with respect to deer, I think that the approach that you're taking, you know, if we are going to go forward, I'm not comfortable with this approach. I think that using waste and unreasonable use authority, really we're reconfiguring the water rights, and I'm very nervous about it, but at the same time I recognize this can be an effective tool to motivate, and so I'm hopeful that we can maybe tighten the language up so that I'd be comfortable with respect to deer, and I think the approach you're taking with some of the questions you have is very good. The only thing that I would add to it would be on the change sheet at the bottom of, it says page 5, but it's page 1. Mm-hmm. So 5 days in the, you know, after the migration period has ended. I don't think we need 5 days of additional flow. I think it should be within 24 to 48 hours. So I defer to staff on, you know, really what do you need, 24 to 48 hours somewhere, you know, in that time frame. And
Could we make that 1 business day?
Oh,
okay.
'cause
That'd
your
be-
weekend
Yeah,
break.
we were,
Yeah. Okay.
we had the weekend.
Right. Okay, and then the last question, and this kind of goes to if we had sort of a normal adjudicatory waste and unreasonable use proceeding, we'd be asking the question, who's using the water? What are they using it for? Are they using it for livestock? Do they have groundwater supplies? Is there an alternative source? Are they planting a third round of alfalfa? I think all of those questions you know, are fact-based, and it just depends on the circumstance. And also, on the other side, this whole issue of when fish are no longer present. How many fish? 0 fish, 1 fish, 10? I really don't know. And I think that if we were going through the normal process, we would be able to say, okay, are you an alfalfa grower? You've grown 3 crops in 1 season, and you need this for a 3rd crop, and the fish, you know, there are a number in the system, or are we talking about 1 fish and somebody that has livestock and no groundwater source? I don't know that that's an unreasonable use. I mean, that's what makes me nervous about this. So I think that if we could tighten up the language with respect to, and this gets very difficult. I don't know how many fish is, you know, enough or too much. But just 1, and for how long of a period? If fish haven't been present at all for 1 day, is that the appropriate time to step in and say migration over? Or are you waiting a period of days? It's very unclear.
There was a bit of a discussion about that yesterday. We can, with some comfort language, but you may want to address that. And then I want to ask questions about mill deer and
And I'll just say my last, and then I'll
Sorry.
finish, is temperature. I still think we needed a range on temperature. We heard in the other item today that there's a target for temperature on the Sacramento, and there isn't any reference to temperature on this specific amount or even a range.
But why? In some way, maybe I misheard, but what I heard was that yesterday was temperature could be an issue, but what they're focused on is the ability of a fish to skittle over a riffle. And if they can get over the riffle and it's warm to get to deeper water, then it'll be cooler. So they weren't going after temperature, which might even be more limiting.
Right.
This was mobility rather than ability to spawn.
Right, but-
Because usually when you're talking temperature, you're talking those pools and refugia where they're hanging out for a while.
Right, we're talking about long-term exposure, and in these reaches, we're really looking at transport through a very short reach of stream, which